Walper-Bossence. She'll be talking about wills and estates, and she's a local lawyer. I will turn it over to Brenda, and thank you very much for coming.
Hello, everybody. Just a bit of a reminder, could you turn your cell phones off or have them on silent, please? So I'm going to talk about predominantly wills and estates. If we have time, I'll talk about some other things, but we may or may not have time. So 3 documents everyone should consider having. Ensuring that your wishes are known and respected, both during your lifetime and following your death, is an important aspect of any plan for the future. While you are alive and well, communicating your wishes and controlling decisions that affect you is fairly straightforward. In the event that you lose your ability to communicate or your capacity to make decisions, things can get more complex unless you have planned for such an event. And if you should die without properly setting out your wishes for your estate, you will lose all control over how it's handled. There are 3 different documents that can help ensure your wishes are known and honored. It's important for individuals to understand what each document can and can't accomplish. A healthcare directive lets others know your wishes concerning your health care treatment in the event that you lose your capacity to make or communicate such decisions. There's one chair here, and I think there's one at the back, ladies and gentlemen. Generally speaking, a healthcare directive provides your doctor or other health professional with directions about the types of medical treatment or measures that are acceptable to you. An enduring power of attorney, the second document, authorizes another person to act on your behalf and will continue in effect even if you later lose your legal capacity. It can be set up to deal with both your property matters, such as banking, investments, leases, or sales, as well as your personal affairs, such as where you live and how your personal care needs will be met. The third document, which I'll spend quite a bit of, that's my topic today, is wills. If I have time, I'll go back to the healthcare directive and the enduring power of attorney. So a will covers the distribution of your property or estate after you die. Properly drafted and executed, a will can help ensure that your property is divided the way you intend and benefits the people you intend. As you can see, these 3 documents deal with 3 very distinct areas of planning for the future and cannot simply be used interchangeably. Together, they provide a good measure of security that your affairs are in order, regardless of what the future holds. As these documents are legal documents, it's important to understand what is required in order for them to be effective. Okay, so starting with a will. What's the purpose of a will? As I said, the purpose of a will is after you die, whatever you say in your will is to take effect. What a will does not do is cover any time before your death. It only takes effect on the instant of your death, not before. What makes a valid will? Okay, so there's some legal requirements. There's 2 methods of making a will in Saskatchewan. The first requirement is for it to be signed and have 2 witnesses who both see you sign at the same time as they see each other sign. There is another method in Saskatchewan to do a will, and that's called a holograph will. A holograph will, the word holograph is Latin for totally and solely in one's own handwriting. Okay, so I want to tell you a little story about a holograph will. One of the more famous and tragic examples of a valid holograph will is the one signed by Cecil George Harris in contemplation of his imminent death. On June 8, 1948, Cecil became pinned between his tractor and one-way disc when he mistakenly put the tractor in reverse while servicing the equipment. His left leg was caught under the left rear tractor wheel, leaving him sitting in a reclining position on the drawbar connecting the two implements. We might have some farmers in this group. I'm a farmer's daughter and a farmer's wife, and now a farmer's mother, so okay. At some point, this man, Cecil, began to realize that he might not survive the ordeal. He therefore used the punch blade of his knife to etch his will into the rear fender of the tractor. And he said, or he etched in case I die in this mess, I leave all to the wife, Cecil George Harris. Cecil was extricated from between the implements by neighbors some 10 hours later after he was discovered by his worried wife. He had apparently been conscious the entire time and remained conscious upon being released. However, he made no mention of the will, and it was not discovered by his neighbors until 2 days later, at about the same time he died from his injuries. The fender was then removed from the tractor, and after establishing the handwriting was that of the deceased, it was accepted as a valid holograph will. The judge ordered that the original will be kept on file, and this piece of fender was cut off and retained at the Probate courthouse for some years until the Probate courthouse closed in 1996, and then the fender and the knife that was used was turned over to the College of Law, and it's there for public display. This is one time where British Columbia or Ontario didn't make law. Saskatchewan made law. That was considered, like that was a new thing to have a holograph will. And so since 1948, we in Saskatchewan, I don't know about other provinces because I don't care, but in Saskatchewan we have the ability to make a holograph will because of Cecil George Harris. Okay, so what is a holograph will? A holograph will is totally and solely in one's own handwriting, dated and signed. Those are the minimum requirements. If it's more than one page, it needs to be dated and signed on each page. The difficulty in holograph wills is that the signature has to be proved and the handwriting has to be proved after death to be the handwriting of the deceased. So that's an extra step. Whereas if you do a will, say in a lawyer's office with 2 witnesses, then that handwriting does not have to be proved as the handwriting of the deceased because the witnesses actually saw the deceased sign the will. So that's the 2 ways of making the will. But with a holograph will, there is that extra step to prove the handwriting was the handwriting of the deceased. Okay, who can make a will? Anyone over the age of 18 in Saskatchewan, over the age of majority, can make a will, or a member of the armed forces. Sometimes persons have been known to lie and get into the armed forces before they're 18, and if you are admitted to the armed forces, then regardless of your age, you can make a will. Those are the 2 categories. And you also have to have the mental capacity to make a will. So an adult handicapped person may or may not have the capacity to make a will, or an older adult who is perhaps suffering under some mental illness or suffering under a disease such as dementia or Alzheimer's may or may not have the capacity to understand what they're signing, and the key is to do they or do they not understand what it is that they're signing. Why should I have a will? Well, easily put, the deceased's wishes can be carried out. In a will, your basics are to have an executor, So what's an executor? The executor is the person who handles your affairs, pays your bills, arranges your funeral, does what I call the chores of the estate. So that's an executor. You also should have an alternate executor if the person that you name is perhaps liable to travel with you, like your spouse or your child. If you're liable to travel together, even if you're not, you should still have an alternate executor, someone who would act in place of the first named executor if that first named executor couldn't act or was deceased. The next item is to have, if you're not a really young crowd here, but if you have children, you need to name, under age 18, you need to name, well, some of you are a young crowd, yes. You need to name a guardian for the children. Now, presumably that's your spouse or the parent of your children, the other parent, but not necessarily so if the other parent is not involved or if the other parent is deceased. You need to name a guardian for your children. And that's while they are under the age of 18 in Saskatchewan. You need to consider what that executor is going to do, and that would be bequests. And bequests can be very general, like I have 3 kids, so everything I've got goes to my 3 kids in equal shares. Or you can be very specific, such as certain items according to a list that I make, and those certain items like the piano and the bureau drawers and the this and the that. You can be very specific in that list. You can also do things like vehicles or pieces of land or property. You can be specific as that, or you can be very general. It's up to you. You should also have, and will have, a paragraph in your will about your just debts being paid first. That's the law. The debts have to be paid, whether that's your last set of utility bills and perhaps your property taxes, depending on what time of year you pass away. You still have to have a clause saying my bills have to be paid. You have a clause in there about directing your executor to sell or not sell certain property. That wouldn't include, for instance, if you said, well, I want my vehicle to go to my oldest child. So that clause to sell or not sell property and call it into cash would not include the vehicle that you've already said goes to my oldest child. There may be special considerations that you need to think about in your will, like a common law relationship, or perhaps children from previous relationships. Second marriages sometimes are not where you say everything to all of my kids. You may have to do some thinking in terms of the children of a previous relationship of yourself or your spouse. In having a will, it reduces cost and it reduces the difficulty in administering the will, the estate. Okay, so if you don't have a will, the power for the person to act stems from the court appointing that person. If you have a will, the power to act stems from the instant of the death of the person. So the executor has the ability to sell the car the next day, transfer the car to the oldest son or oldest child in my example the next day, because that's what the will said. The cost is far less. If there is no will, I have a little sidebar. If there is no will, so pretend that you have no will. Whether you like it or not, you do have a will. When a person dies without having made a valid will, for practical purposes, the laws of descent and distribution of this province become your will. The following is a not too far-fetched summary of the will which you haven't made. It does vary from province to province, but for all intents and purposes, it will be the pattern of distribution unless you prepare a will. So this fellow says, being of sound mind and memory, I hereby publish this as my last will. First, I give my wife all of my possessions. Secondly, I appoint my wife as guardian of my children, but as a safeguard, I require that she report to the court and to the public trustee every year and render an accounting of how, where, and why she spent the money necessary for the proper care of my children. As a further safeguard, I direct my wife to produce to the probate court a performance bond to guarantee that she exercises proper judgment in the handling, investing, and spending of the children's money. As a final safeguard, my children shall have the right to demand and receive from their mother a complete accounting of all of her financial actions with their money as soon as they reach legal age. When my children do reach legal age, no one shall have the right to question their actions on how they decide to spend their respective shares. Should my wife remarry, her second husband shall be entitled to 1/2 of everything my wife possesses. Should my children need some of this share for their support, the second husband shall not be bound. This does apply for husband-wife. This is an old piece. The second husband shall not be bound to spend any part of his share on my children's behalf. The second husband shall have the sole right to decide who is to get his share, even to the exclusion of my children. Third, should my wife predecease me or die while any of my children are under the age of 18, I don't wish to exercise my right to nominate the guardian of my children. Rather than nominate a guardian of my preference, I direct my relatives and friends to get together and select a guardian by mutual agreement. In the event that they fail to agree on a guardian, I direct the probate court to make the selection. If the court wishes, it may appoint a stranger acceptable to it. Fourth, under existing tax law, there are certain legitimate avenues open to me to lower taxes at my death. Since I prefer to have my money used for government purposes rather than for the benefit of my wife and children, I direct that no effort be made to lower my taxes at death, in witness whereof. So that's a little bit of a parody, but it is very close to what would happen if you died without a will. So a will should contain a clause to cancel all other wills. It should name executor and the alternate. It should name a guardian if you have children under age 18, and you should also name an alternate guardian. It will dispose of your assets, such as your small items, your larger items, land, and money in the bank. There is a restriction on who you can will your property to. In Saskatchewan, you must provide for your dependents. So that would be your spouse is considered to be a dependent, and any child under age 18 is considered to be a dependent, and any dependent adult child who is handicapped in some way. Family property, you can't disinherit your spouse unless you are separated from the spouse, but your spouse must be provided for, and your underage children must be provided for. Be aware, though, that your overage children, that is over 18, do not have to be provided for. Not at least in this province. I know British Columbia is different, but in Saskatchewan you don't have to. And I have a little sidebar for there. Dear Ann Landers, let this letter be a wake-up call to all sons, daughters, and grandchildren. The message I want to convey is this: your inheritance is not automatic, it's a gift. The writer, I am an estate planner. Over the last several years, I've seen many clients change their wills, bypassing children and grandchildren, and leave their money to friends, charities, and people they once worked with who were kind and helpful. There are many reasons for changing a will, but the two most common are disrespect and isolation. In some families, the only time the old folks see the grandchildren is when their parents need a favor. Usually it's money. So what the old folks are basically saying is, to heck with you. You didn't want to make time for me when I was lonely and would have loved your company, so why would I leave you the money that I worked for all my life? Wake up out there. An inheritance isn't something that is owed to you. It is a gift of love. When there is no love, there should be no gift, and this is signed by a fellow in Florida. And then Ann Landers replies, I have a hunch today's column is going to generate some phone calls and letters to aunts, uncles, and grandparents who haven't heard from their kinfolk in quite some time. Your letter was more than a wake-up call. It was a shake-up call. I'm glad you wrote. Okay, so how can a will be changed? You can cancel a will by making a new will, or you can destroy it by tearing it up in front of a witness or two. Or your will is also changed in this province if you get married. Your will that you have, which is dated prior to the date of your marriage, is null and void, period. You need to make a new, even if you say the same things before your marriage to your partner, and now your partner is your spouse, even if you say the same things, it has to date after the date of your marriage. If you get divorced, your divorce does not absolutely nullify your will. It only nullifies the paragraphs that relate to your spouse that is now divorced from you. So the paragraphs that you're giving things to your, it's as if those paragraphs don't exist. So I nominate my spouse as my executor, and ultimately I nominate my oldest daughter. So if the spouse and the person making the will are divorced, it bumps automatically down to the daughter. And if you establish a new relationship, so the definition of spouse in Saskatchewan is legally married or living together with someone for 24 months or more. So on the 25th month, you are as if you're married, and that nullifies your will that predates that 25th month, okay? So you would have to, even if you say the same things in your will, the date of your will has to date after the date of your 25th month where you were living together. You should always destroy your old will when you've made a new one. That alleviates the problem of your kids or someone finding the old will, starting to work on that, and then 3 weeks later finding the new will and going, oops, that's not what mom and dad wanted, or mom or dad wanted. I guess we have to get the piano back from, and that makes for bad feelings. So, and mind you, you won't be around, so it won't matter to you, but it does matter to your kids. So please do destroy the old will when you make a new one. And there should only ever be one signed copy of the will. You can make copious photocopies, but there should only be one signed one. And that's for the reason that if you decide to destroy it, you take that and you rip it up, or you take that and you make a new one and get rid of the old one while you're doing it, so then it's all one smooth motion. Okay, so we talked about holograph wills or making a will in a lawyer's office. The advantages of writing your own will is cost saving. Although cost saving, wills are between $200 and $300, so it's not a great deal of money. It's money, but it's not a great deal. But there is cost saving. You write your own will, you're done. The disadvantages of writing your own will is, one, there's no advice for estate planning, because generally speaking, your lawyer would have a conversation with you about what other things do you need. Does this conflict with your RSPs or your RIFs? Does this conflict with your insurance beneficiaries, so on? It also might not satisfy the legal requirements of a valid will, and it may not actually represent the writer's intention, because the writer was perhaps unaware of legal interpretations, such as what I've just described to you about what a legal spouse is, both a 24 months or more living together or a legally married spouse. I have a little quote in here from somebody. I won't be able to find it now. Anyway, the best thing for a lawyer to see is a holograph will, because it usually means potential litigation. It's not mom's will because it's not her handwriting. She forgot me. She gave something to every other child, but she forgot me. Most of those can be offset with a lawyer asking, well, shouldn't we have a paragraph in there that says I'm not looking after my oldest daughter because I haven't seen her for 10 years? Or oftentimes the lawyer can generate a discussion about why you should have something in there and why you shouldn't. But certainly you have the right and have the ability to make a holograph will. Where should a will be kept? A will should be kept in a safe deposit box. In Saskatchewan, you do have the right to lodge your will at the courthouse. I think it costs you $10. It might be 12 by now, but it's very, or you can keep it at home with your belongings. If it's at home, you should, I strongly suggest you have a safe or a safe deposit box or a strong box that's fireproof or fire retardant at home. Or worst case, that it's in a metal filing cabinet. At least that would be as safe as you can get from fire. And you also can keep your will with your lawyer if you chose to. So in terms of your will, if you have a jointly owned piece of property, supposing you and your spouse own your home or a piece of farmland or cottage of the lake, you cannot give that piece that is jointly owned away under your will to anyone else. It is, if it's jointly owned with right of survivorship, that means your spouse gets it, period. Land ownership and will, if there's a difference in the will, the land ownership, how the title reads, trumps the will. So you cannot give it away differently in the will, even if you wanted to. Similarly, insurance policy, and I've seen it happen more than once. People get married, they give in their will everything to my spouse, and then they pass away, and there's a policy of insurance that's still to my mother. It goes to the mother. If that's the beneficiary on your policy of insurance, that's who gets it. No matter what the will says, everything to my spouse, the policy of insurance beneficiary trumps the will. So if you are thinking about that, it might be wise to look at your policies of insurance and see who actually is the beneficiary, and is that who you want. Same with your RIFs or RSPs, or tax-free savings accounts now. You need to look at those. If you say, I want everything to go to my children, and at the time that you took out that tax-free savings account, you were mad at your kids, and you said, I'm going to put my niece on as beneficiary of the tax-free savings account, then you need to think about that if you're making your will saying, okay, remaking your will and saying, I want it all to go to my kids. You need to take a look at your policies of insurance, your RSPs or your RIFs, and your tax-free savings account, and then your joint property too. If those are all what you want, and you say, okay, everything to my kids, but I have this godchild that I want this particular policy of the insurance to go to, and that works for me, good. But you need to think about that. In an estate plan, you need to look at all of your beneficiaries or your jointly owned property. If you have, you might decide to have your house, okay, you're now a widow or a widower, and you might decide to have your house into your names of your kids. That's perhaps a good plan, but there are drawbacks in that. If you put your children's name on the title to your house, drawback number one, so okay, in my scenario I'm going to use mom and 2 kids. Okay, drawback number one, that child now owns 1/3 share of mom's house. Now, right, because the title has been transferred now. It's not in the will. Doesn't matter what the will says, the ownership is now 1/3 to my child. And then that child has a rocky marriage, and the rocky marriage turns south, and that child's spouse says, What does my spouse own? Oh, my spouse owns 1/3 share of my mother-in-law's house. So then that house becomes at risk for 1/6 share in my example. And mom, I will have to perhaps sell her house, not likely because it's only 1/6 share, but might have to fork over some money to help the child because that house is now at risk through family property division between the child and the child's spouse. Okay, that's drawback number one. Drawback number two is bankruptcy. If you put, in my example, mom and 2 kids, and the one child goes bankrupt, their own house is exempt from bankruptcy because they live there. But your house, that is now 1/3 your child's, you're going to have to either sell the house and fork over 1/3 of the value into the bankruptcy court, or gather funds equal to the value of 1/3 and put it into the bankruptcy court. Your child, if your child lies and says, well, I don't own anything else, I just have my house and that's it, and the bankruptcy court will find out that there's a 1/3 share in mom's house, then that's perjury and your child can go to jail for not telling the truth. Okay, so that's drawback number 2. Drawback number 3 is now that you've got you and 2 kids, your 2 kids on the title to the house, and you decide you're going to sell it, you don't now have a committee. The house that you could choose to sell or not sell on your own, now you need your kids' permission to sell it because they are also on title. And it isn't majority rules here. It's all 3 have to sign. And I will give you an actual Saskatchewan example. Dad, out of Saskatoon, Dad was 88 years old. He decided that he was going to, his condo, he was going to put his only son, he only had the 1 child, his only son on the title. So now we have dad and son on dad's condo title. And then he's 88, and there was never any question of his mental capacity. He was smart, he knew what he was doing, it was all okay. Then he's now 92, and he says, well, you know, I think I like the weather better in BC. I'm going to move to BC. I want to sell my condo and move to BC. And the son says, and not that the son was bad or persnickety or vindictive. The son said, no, Dad, you're making a bad decision. You know, I can't look after you. I'm your only child. I can't look after you. Your move to BC is a bad decision. I'm not going to let you sell your condo. The dad took the son to court. And again, this is a Saskatoon case. The dad took the son to court, and the judge said, yes, you can sell your condo, but you have to pay half of the value to your son. And then because all of a sudden the value of his condo diminished, he couldn't move to BC because he couldn't buy anything in BC because he's only got half of the value of the condo. So that's a reason not to put your kids on your title. And then the 4th reason, which is simply that you do that, and then at your passing, you might not own it. You might have sold it already, right? So then you've done that expense of putting it into your name and the 2 kids, and have ended up selling it before passing. So that's not as onerous a reason, but the 3 reasons, firstly, are you need to be aware, is all I'm saying. And my approach is, I don't not put titles into joint names. I will do that. But you as an individual need to know the drawbacks. And then you as an individual make the decision. You assess the risks. I don't tell you not to cross the street. I tell you, if you cross your street, then look both ways. And then make a decision. If that's still what you want to do, okay. But think about the possible consequences in regards to your kids and your family. Okay, so administering an estate. The person who is your executor would be the person that is named in the will. Be aware that your person, the executor, can refuse to act. So it is appropriate that you ask your executor before you write that person down and have that person be your executor. And similarly with your alternate executor, you need to ask them, would they be willing to do the chores of the estate? If they refuse to act, an executor can be replaced, but it's extra business for the estate to do, and so then that's a cost that is over and above costs. So what are the responsibilities of an executor? The executor has to gather the information about the assets and information about the debts and follow the terms of the will and follow the terms of the law. That's basically, in a nutshell, what an executor has to do. The process is oftentimes the executor can do lots on their own, but it may be that the executor will need a lawyer. The lawyer does all of the paperwork, the executor does all of the legwork, in short, gathering the information about the assets, arranging to dispose of the contents of the house, arranging to sell the house, or arranging to turn the house over to a beneficiary, if that's what the will says. There is the application to court, and I will get to fees too, but the application to court, if there is a will, it's called an application for probate. If there's no will, it's called an application for administration. The application to court, generally speaking, the banks are of such a mind that anything under $50,000 worth of assets does not require the application to court if there's a will. If there's no will, it really doesn't matter how many assets. The banks and financial places will insist on the application to court. Because there's no will, there's nobody that is actually pointed to as the person who's looking after the will. So if there's $50,000 or more, it's an application to court is required. What's an application for probate? What does that mean? It is essentially, dear judge, here's the assets, here's the will. I'm the proper person to administer the will, or you are. And now let me go ahead and administer this will. So that when the judge receives the application, the judge makes the decisions on, is this the right will? Is it the only will? Is it the last will before the person died? Was it made properly? Did the person have their sound mind? Were they under any influence by others or under the influence of drugs or alcohol? Were they, did they provide for the proper people? That is to say, did they provide for their wife? Did they provide for their dependent children or dependent adult children? So that the judge then looks at the actual executor. Has the executor promised on oath to administer the will according to law and according to the will? And so then when letters probate issue, all of those questions are asked and answered by the judge. So that letters probate, if I'm sending letters probate to the bank, they don't have to answer or ask and have answered any of those questions, because the judge has said letters probate issued, here's the executor. So all they do is say, oh, okay, where do we send the money? If there's a small estate, the risk to the bank is lower, so they are prepared in most instances to send funds out without probate. So, but then they have to make it's their risk assessment. You know, what about the questions about, was there another spouse that didn't get looked after? Was there two spouses? Because in law, in Saskatchewan, you can, in theory, have two spouses. One that you're legally married to and separated from, and one that you're living common law with for 24 months or more. So, in theory. Well, it's more than theory, it's actual. So then, $50,000 or less, it's not a rule of law. It's a rule of thumb that the banks use. They're prepared to ask all those questions and then release the money. Whereas $50,000 or more, they're not prepared to take that risk. And so then they require, generally speaking, they require letters probate. Now, if there's no will, again, there's no 50,000 less or more. It's, you've got to apply to court. So then once letters probate issue, then there's not a literal, but a call for the funds to come. The executor is then required to pay bills, and the executor is then required to, including income tax, don't forget income tax, is required to disperse the funds to the beneficiaries in accordance with the terms of the will. Income tax is an issue all itself. I don't do any income tax as a lawyer. I don't know that many lawyers do. It's referred to, that part of the estate is referred to the tax people, whether that's an accounting firm or a bookkeeping firm or part perhaps. So then the steps of administering the estate, I think, are in that booklet. I just touched on some of them. I'm pretty sure that they are. So I'm looking at the time here, and I do want to touch on a little bit on powers of attorney and a little bit on healthcare directives, but I know people are interested, I believe people are interested in costs of an estate. What does it cost? I did want to say, in the event that there is land in the sole name of the deceased, that isn't a rule of thumb, it's a rule of law. The Land Titles Act says we won't let this land be dispersed to the beneficiary without letters probate. So that's, you don't have a choice there. Unless it's surviving joint tenant, where the land is in joint names with the deceased and a spouse or the deceased and someone else. Okay, so fees and costs. The first fee is the court fees. Court fees are $7 per $1,000 of assets. It's also called a probate fee. It's also called the government fee, but that's the formula is $7 per $1,000 worth of assets plus $200 in administration fee. So on $100,000 worth of assets, it's $700 plus the $200 admin fee, so that's $900. Okay. And that's a flat fee. It doesn't matter whether there's $100,000 worth of assets or $1 million worth of assets. It's $7 per $1,000 plus $200. Okay, there's no GST and PST on that. That would be considered a tax on a tax because $7 per $1,000 is sort of a tax. So, the next fee is the lawyer's fees. The formula is $1,500 plus 1% up to $500,000. So on a $100,000 estate, it's $1,500 plus 1%, so that'd be $1,000. So it's $2,500. From $500,000 to $1 million, it's 0.75%, and anything over 1 mil is 0.5%. So you've got $1,500 plus 1% up to 100,000 plus, and then 0.75% plus up to 500,000 and 0.5% above 1 mil. Okay, that's legal fees. GST and PST does apply to the legal fees. There are accounting fees. There will be a requirement for just a quick version of what's required for tax and what the executor has to do. Supposing the person died September 16th, okay, of 2021. January 1st to date of death, that income tax return is done in the ordinary way. Then date of death to date of winding up, which would be sometime between the date of death and December 31st, generally speaking. Date of winding up is an arbitrary day that's usually set by the executor and the accountant. What day did the deceased stop earning income? And then that return would be filed as a death return, or they call it a trust return, or it's a T3 return. Those are the two returns for the year of death. Okay. The accountant would not, okay, so a person dies now, today, the accountant wouldn't probably be doing those returns until next spring, until all the slips are in. What's earned by the deceased after death? Well, just because he's passed away or she has passed away doesn't mean he or she has stopped earning any income. You earn income until you don't. So that interest income on investments doesn't stop because you died. It continues until that investment has been de-invested. The death benefit of $2,500 that's due to most all of us, that's taxable in the estate's hands. You get $2,500 and you pay $660 tax on it. Wonderful, but it is what it is. So then there's income tax to pay both before and after death in the year of death, 2 returns. After the returns are done and the notices of assessment come back at 0, it is typical, and I advise it, that the executor apply to Revenue Canada for what is called a clearance certificate. That little slip of paper is only about that big, but basically what it says is all tax payable for this deceased person has been paid forever. And that's what you want. As an executor, you want that. You want, number 1, to know that your liability is done in respect to tax. And number 2, you can get rid of all the papers and bits and pieces and income tax returns and boxes of stuff because you've got that clearance certificate. Okay? And so then there will be accounting fees to do both of those returns. It's hard for me to judge what the accounting fees might be. It depends certainly on whether the person who died had an active business or was a retired person or something like that. There is also the notice to creditors. I'm sure you've seen them in the paper. Take notice that all creditors have to come forward by such and such a date. As of now, Mooshnell Express charges $268 for that. So that is a cost, that's including taxes. And that is a necessary requirement if probate is applied for, because it's part of the Administration of Estates Act. You got to do it. Executors fees. An executor has the right to charge an executor fee. An executor fee, at least in this province, is anywhere from 1% to 5%, but typically it's 2%, unless it's an extraordinarily complex estate where perhaps the fellow was a bachelor and he died as a farmer and he had cows to sell and he had land to finish farming and so then nieces and nephews or whoever is the executor has all that to do. So that would be more complex than a retired person who has money in the bank. So it depends on what the executor does, but that's the range from 1% to 5% of the gross value of the assets at death. Okay, I'm going to move on to just a little bit on find it here. Yes, okay, powers of attorney. Who can give a power of attorney? Same thing, a person has to be of legal capacity, have to understand a document. A power of attorney is that document which you as of sound mind decide to, in case that you have a stroke or have a heart attack or something that leaves you not capable mentally, not capable mentally than physically not capable, because you can still get to the bank or you can still sign a check. But if you're not mentally capable, you can give a power of attorney. Power of attorney is like buying insurance. You don't buy insurance because you're going to have a fire. You buy insurance because if you have a fire, you're prepared. You're prepared as you can get. And that's what a power of attorney is. You do it now before you need one, because if you need one, and you have that stroke, you may not be able to understand what you're doing, and then it's too late. Too late meaning it's not too late to get governance of your children or your spouse to get governance of your affairs. But the power of attorney is about, again, between $200 and $300-ish in this town. If you don't have a power of attorney, and if you have that stroke or that heart attack or develop dementia, I had a fellow whose son came to me and, nope, Dad said he's not going to have any, he's going to just drop dead and he's just not going to need a power of attorney. Well, he did. And that process, because he refused to even think about a power of attorney, that process is called an application for guardianship, either personal guardianship or property guardianship. And I don't mean just real estate property, I mean property in a general sense. That process is called an application for guardianship. Compared to $200 to $300, that process is between $2,000 and $5,000 to do, depending on the legal fees and the person who's doing it, the lawyer who's doing it, but that's your average cost. It's an application to court. The guardianship requires 2 medical professionals to say that this person is not capable of signing documents or signing checks or doing their financial business, or not capable of doing their personal business, such as you're leaving the tea towel on the hot stove one too many times and you don't know that you don't know, or that you're wondering and you don't know that you don't know. So personal decisions as well as financial decisions would be covered by the applicant. For guardianship, it requires the 2 medical certificates. It requires the public trustee to agree that the person who is applying is a good person. That person who is applying has to have a criminal record check. That person who is applying has to have a bond. Bonded is the process, like if you were working for a bank, you would have to be bonded as an employment bond. The bond that the person who is applying for guardianship is called an administration bond. It has nothing to do with an estate. It's simply to administer the person who is incapable administering their money. So that if you're looking after someone else's money, you need to be bonded. Same idea. Okay? So that it's way less expensive and way less hassle to just simply get a power of attorney before you might need it. Anyone who is, same as a will, anyone who is an adult who has capacity to understand what they're signing can do a power of attorney. And whoever you choose to be your power of attorney, you need to choose wisely. That is to say, it can't be a bankrupt person, because, for instance, bankruptcy tells me that that person isn't able to handle their own money. Maybe they're not a good candidate to handle your money. It can't be anyone who has had a criminal record to do with money. And I'm not talking, I mean, a criminal record is a .08. I'm not downgrading that. The criminal record is associated with money things like fraud or bad checks or those kinds of things. That's what and then the power of attorney needs to, if that person had been bankrupt or if that person did have a criminal record, the power of attorney needs to know, or the person making the power of attorney needs to know that and agree or consent that I still agree that my child who has had a bankruptcy can still be my power of attorney. The duties of an attorney are to look after finances, if it's a property and financial power of attorney, and to look after the personhood of your person granting the power of attorney, or both. You can do a personal attorney, you can do a financial power of attorney, or you can combine it in one. In my family, my mom needed a power of attorney. Well, my brother was very, very, very good with money. His background was accounting, but he wouldn't have known whether my mom needed to have socks on her feet because she had cold feet or not. He just wouldn't pay attention to that. So mom had her personal attorney being my sister and her financial attorney being my brother, because that fitted us in our family and it fitted my mom. So that's something that you can split out as personal and financial, or you can make the same person be your personal and financial power of attorney. The power of attorney can be contingent on certain things happening, like I don't want my power of attorney to act unless there's been 2 medical people saying that I'm not capable. Okay, that's a contingent power of attorney. It can be general or specific. Most of the time you would want generally to have your power of attorney do everything that would be needed to do. I'll give you an example of a specific power of attorney. I had a pilot client who was in he was in the Middle East 3 months and then he would be home 1 month. Okay, that was his job. And he wanted to sell his house. So he said, he wanted to nominate me as his power of attorney, but only specifically to sell the house. I didn't have access to his bank account, I didn't have access to his investments, I didn't want to. He gave me the specific power of attorney to sell his house, and that was the days before faxes and emails, because this is a long time ago. He gave me the specific power of attorney to sell his house. He had to determine price, but I could sign the documents. So that's a specific power of attorney as opposed to a general power of attorney, because most folks need a general power of attorney to cover everything that needs to be done. You can end a power of attorney by changing it and revoking it, or you can tear it up again. But if you have given copies to your child or to the bank or to the financial place, if you're revoking it, you need to make the rounds and let everyone know that you've revoked it and made a new one. Okay, this very quickly on healthcare directives. What we used to call a living will is now called a healthcare directive. When I first started doing living wills, they were not legislated. There is legislation now in Saskatchewan, and it's called a healthcare directive. A healthcare directive is not euthanasia or assisted suicide. It is not that. Basically what it is when it's my time, don't keep me alive by artificial means. Don't hook me up on machines. I want to die at my own pace. I don't want, you can say some of these or you can say all of these in your healthcare directive. I don't want, for me, I don't want experimental drugs. I don't want experimental surgery. If it's my time, keep me comfortable, keep me free from pain as much as possible, but let me go. That's the essence of what I've put in a healthcare directive. There are variations on the theme, but that, and you can expand on that, or you can use as short as that as well. You can name in your healthcare directive a proxy. That would be the person that would make decisions for you for your health in a terminal illness decision, where so for instance, if I go into the hospital now, I'm going to say yes to surgery or I'm going to say no. I'm going to say yes to certain drugs or I'm going to say no, because I have that capacity. But maybe in the latter stages of cancer, I won't be able to say. So I want this document to say for me, and then I nominate a proxy, because you can't think of every medical thing that might come up. You just can't, and you can't put that in a document. If you name your proxy then would carry out your wishes to the best of that person's knowledge and ability based on what you've written out in about 4 pages. Because again, you can't write out every situation ever. So you can also name an alternate proxy depending on your choice, perhaps, or you can do an either or. Oh, incidentally, in a will, you cannot do an either or. I name my daughter and my son. You can't have either or in your will. You have to name the daughter and the son, or you name my daughter first, alternately my son. In a power of attorney and a healthcare directive, you can do either or. You can also do first and then alternate too, whereby you name your daughter and your son, or either one of them to act. That's available to you for power of attorney, and it's available to you for a living will. And I think I have just shot my time.